comes to solicitor-client relationship, there will be an exchange of services provided by solicitor and remunerations by the client. Hence, a client's account is needed to record transactions relating to clients' monies held by the firm. In Malaysia, Section 78 of the Legal Profession Act empowers Bar Council to make rules that regulates the conduct of solicitors in handling their clients' money to curb any mismanagement of the money by the solicitor. Such rules include solicitors' account rules, accountants' account rules, and solicitors' account deposit interest rules adhere. By virtue of Section 94, non-compliance to the rules will lead to disciplinary proceedings against the advocate and solicitor involved. Meanwhile, in Hong Kong, similarly, Solicitors Account Amendment Rules 2002 and the Accountants Report Amendment 2012 govern on the management of the client's money on part of the solicitor to prevent mismanagement and misappropriation of the monies. The question is, how effective is the Malaysian Solicitors Account Rules 1990 in safeguarding clients' money deposited into the legal firm's clients' accounts in Malaysia? Hence, we shall analyze the effectiveness by comparing Malaysian Solicitors Account Rules with Hong Kong Solicitors Account Rules by analyzing the duties of solicitors towards the client's account.
Client account is a current or deposit account at a bank in the names of solicitor in the titles of which the word client appear. For instance, if the firm name Fatini & Co., therefore the client account will be Fatini & Co. in brackets client account. Under Rule 3, Subsection 2 of the Malaysian SAR, it also provides that solicitor may keep more than one client account as he thinks. Therefore, without further ado, let us discuss about this matter thoroughly.
With regards to withdrawals of money from client account, the similarity between Malaysian and Hong Kong SAR is that both countries strictly prohibit unauthorized withdrawals of money from client account, and this further can be seen under Rule 7 and 8 of the Malaysian and Hong Kong SAR. Rule 7 of both countries provides about the types of money that can be withdrawn from the client account. In Malaysian SAR, Rule 7 paragraph A until D provides about manner in which money can be withdrawn from the client account. Among the types of money provided under this rule are client money, which basically referring to the money required for a payment to or on behalf of the client. Next, we have trust money, which is basically money required for a payment in the executions of a particular trust. We have under paragraph C, such money not being money to which either paragraph A or B applies, as may have been paid into the account under paragraph B or D of the Rule 4. And lastly, money which may by mistake or accident has been paid into the account in contraventions of Rule 6. Under Hong Kong SAR, Rule 7 can be said as pari material with manners in withdrawals of client money as stated under Rule 7 of the Malaysian SAR. Despite the similarity of both rules, Malaysian SAR have a supplementary in withdrawals of client money, which can be seen under Rule 7 paragraph A subparagraph 2, which states in the case of solicited trust money, money properly required for a payment in the executions of particular trust can be withdrawn, and this is silenced under Rule 7 paragraph A of the Hong Kong SAR. Second differences can be seen under Rule 7 paragraph B, whereby Malaysian SAR provide a supplementary in subparagraph 2, which states regarding the money to be transferred to a client account in the executions of particular trust, and this is silenced under Rule 7 of the Hong Kong SAR.
In conclusion, pertaining to Rule 7, we can say that although both countries provide similar content under Rule 7, however, Malaysian SAR is better in a certain way because it provides supplementary subparagraph which is silenced under the Hong Kong SAR. Now, let us move on to Rule 8, which provides another method regarding withdrawals of money from the client account.
Rule 8 of the Malaysian SAR provide two methods of drawing money from client account, namely a cheque drawn in favour of a solicitor, and this method is by issuing a cheque payable to any solicitor and prohibit the issuance of a cash cheque. Secondly, a transfer to bank account in the names of the solicitor not being a client account. The solicitor can advise the bank to transfer the legal fee from client account to office account since this money belongs to the solicitor. Now, let us look at Rule 8 of Hong Kong SAR, which basically contains the same content as Rule 8 subsection 1 of Malaysian SAR, except for the subparagraph mentioned under Rule 7. Apart from that, the similarity of both rules can be seen under Rule 8 subsection 2, which provides no money other than money permitted by Rule 7 to be drawn from a client account shall be so drawn unless with the authorization from the Bar Council for Malaysia and Council for Hong Kong. Therefore, application must be made to Bar Council or Council, and once it is authorized in writing, then only the solicitor can withdraw such money legally. However, the differences of Rule 8 for both countries is that in Malaysian SAR, there are supplementary paragraph in regards to the manner in withdrawals of money from client account, which is silenced under Hong Kong SAR. Paragraph 3 of Rule 8 of the Malaysian SAR provides that with the exceptions of matter allowed by the client, disbursement, payment or advance of money, no withdrawals by cash, cheque or a barrier cheque can be made. Next, paragraph 4 provides the withdrawals of clients' money from the ATM, telephone banking service and online banking service is forbidden but not extended to payments made to the relevant authority and must be authorized by the Bar Council. Lastly, under paragraph 5 states money held for a client must not be used for payment of another client without prior written instructions of the client for whom the money is held.
In short, it can be said there is a slight difference between the law governing the withdrawals of money from client account between the Malaysia and Hong Kong. However, it can be said that Malaysian SAR is much more prominent because it provides more restrictions regarding the withdrawals of money from client account as compared to Hong Kong, and this can be seen under Rule 8 paragraph 3, 4 and 5. Now, let us move on to the next part, which is regarding reconciliations of bank account.
Reconciliations refer to an accounting procedure that compares two sets of records in order to make sure that the figures are correct. The importance of reconciliation can be seen in the case of Serenity anak perempuan Nixon and Harrison Logistics Centre Berhad, where the court mentioned that actions of the claimant willfully refused and fails to submit the accounts reconciliations to her senior accountant may tantamount to insubordination. Under Rule 11, Subsection 4 of the Malaysian SAR, it states that every solicitor must reconcile the balance of his client's cash book with his client bank statement once in 6 months and shall keep it in the cash book or other appropriate place a statement showing the reconciliation. While in Hong Kong, under Rule 10 capital A, it states that every solicitor is obliged to compare the balance shown on client's cash book with the totals of the balance shown on the statement and passbook and any client's money or trust money held by the solicitor in cash at least once a month.
Reconciliations of account is an important accounting safeguard in order to ensure that there is no fraudulent practice or abuse of client money had taken place. So therefore, among the improvement that we can make to the Rule 11 Subsection 4 of the Malaysian SAR is to strengthen it with the compliance mechanism and provide it with sanction provision in order to ensure that the solicitor always complies with the reconciliation process.
This duty is stipulated clearly under Rule 3 of the Malaysian SAR. Similarly, under the Hong Kong SAR, it is governed under their Rule 3 as well. The rule states that, subject to Rule 9, every solicitor who holds or receives client's money or money which under Rule 4 he is permitted and elects to pay into a client account shall, without delay, pay such money into a client account. It can be seen that Rule 3 for both SAR is the same. Both countries require their solicitor to pay money without delay into the client account. The rationale behind this is pretty straightforward, which is to prevent any misappropriation of client's money when it is in the hand of the solicitor. The delay of such payment may have resulted in a misappropriation of client's funds and may have caused the solicitor to be suspended from continuing his legal practice as an advocate and solicitor. This scenario can be seen from the case of Marzaini binti Zainuddin and Majlis Peguam Negara that happened in the year of 2007. What should be paid into a client account? As stipulated under Rule 3 of both SAR, money stated under Rule 4 must be paid into the client account. Those are trust money, such money belonging to the solicitor as may be necessary for the purpose of opening or maintaining the account, money to replace any sum which may by mistake or accident have been drawn from the account in contravention of sub-Rule 2 of Rule 8, and a cheque or draft received by the solicitor which under Rule 5 he is entitled to split but which he does not split. Again, it can be seen that both SAR provide for the same type of money that should be paid into the client account. This has emphasized further the importance of complying to the duty stated under Rule 3, which is to pay into the client account. Where the money mentioned under Rule 4 is not paid immediately into the account, then the issue of misappropriation of client's money may arise.
However, despite having the same duties stipulated under Rule 3 of each SAR, nevertheless, the Malaysian SAR does not impose any rules in the event that the solicitor had failed to deposit the client's money on time and mention anything about the interest on client account.
Unlike the Hong Kong SAR, their Rule 6 A has provided for the interest on client accounts. The general rule is that the solicitor must without delay deposit the money in a designated interest-bearing client account in each occasion when a solicitor holds or receives client's money in respect of a particular matter. This rule also dictates the solicitor to be held responsible for any interest earned on the account. In the event that the solicitor had failed to deposit the money on time, the client is entitled to ask the solicitor to pay a sum equivalent to the interest which would have accrued for the benefit of the client if the money had been deposited in a Hong Kong dollar savings account of the Hong Kong and Shanghai Banking Corporation Limited.
To analyse the rules governing the duty to pay money into the client's account, it can be seen that both Malaysia and Hong Kong SAR provide for the same thing, in which the money should be deposited into the client's account immediately and without delay. Nevertheless, in the Malaysian SAR, it does not provide anything on the interest for client accounts where the money is deposited like Hong Kong. From here, it is apparent that the Hong Kong SAR has provided a more thorough provision on the interest. To improve on our Malaysian SAR, it is recommended that the SAR should include a provision for interest too, in which when the solicitor holds or receives money in respect of a particular matter, the solicitor must without delay deposit the money into a designated interest-bearing client account and must account to the client for any interest earned on the account. Failure to do so will render the solicitor to pay to the client a sum which is equivalent to the interest which would have been accrued for the benefit of the client if the money had been deposited in a Malaysian savings account as according to Bank Negara Malaysia.
In the Hong Kong SAR, the rule regarding this is clearly provided under Rule 9 A, which states that any breach of these rules must be remedied promptly upon discovery. This includes the replacement of any money improperly withheld or withdrawn from a client account, and each principal of a firm shall be jointly and severally liable to carry out the duty to remedy any breach of these rules. This duty extends to replacing missing client's money or trust money from the principal's own resources, even if the money has not been misappropriated by the principal himself, and whether or not the claim is subsequently made on the fund established under Rule 3 of of the solicitor's professional indemnity rules. However, in Malaysia, there is no specific rule governing duty to remedy breach in the SAR 1990. Generally, the Legal Profession Act 1976 or the LPA will govern the lawyers as it contains all the laws and rules to be complied with by an advocate and solicitor.
So, where the Malaysian SAR provides the duties towards the client's account, it is however assigned on the duty to remedy breaches. This means that when there is a breach, the provision that will be referred to will not be SAR but instead the LPA. The LPA deals with the professional practice, etiquette, conduct and secrecy of advocates and solicitors. Section 94 subsection 2 of the LPA states that any advocates and solicitors who have been guilty of any misconduct shall be liable to be struck off the roll or be suspended from practicing in the future. They can also be ordered penalty. In analysing between the Malaysian SAR and the Hong Kong SAR, it is clear that the Hong Kong SAR provides a better provision towards the duty to remedy breach. Like Hong Kong SAR, it mentions how any breach of these rules must be remedied promptly upon discovery. Not only that, it also states the person who shall be liable to remedy such breach in which each principal of a firm shall be jointly and severally liable to carry out the duty to remedy such breach. So, where a dispute happens in the future, it is easy for the relevant authorities to refer to the provided rules rather than having to refer to another different statutes.
So moving on to the next duty, which is the duty of the solicitor to keep account as the record of dealings. So for Malaysian SAR, this is provided under Rule 11, and for Hong Kong's SAR, it is provided under Rule 10. So let's take a look.
So, as you can see here, according to Rule 11, Paragraph 1, it states that every solicitor shall at times keep properly written up in national or English language such books and accounts to first show all his dealings with clients' money, and second, to distinguish such money on account of each separate client, and to distinguish such money from other money held. So when you have to keep record of all these dealings, there must be a method. This is provided under Rule 11, Paragraph 2, where the dealings shall be recorded in a client's cash book or a separate client's ledger. In Hong Kong's SAR, according to Rule 10, Paragraph 1, you can see that it is quite similar to our Malaysian SAR, where every solicitor shall at times keep properly written up such books and accounts in order to show his dealings in relation to client's money or any other money dealt by him through a client account, and secondly, to distinguish such money held, received or paid by him on account of its separate client. As for the method to record all of these dealings, it is also similar where it can be recorded in a client's cash book or a client's ledger. However, these dealings shall within 3 working days after the date of such dealings to be recorded. Regarding the differences, there are 2. The first one, for Malaysian SAR, there is no time frame specified as to when must the solicitor keep the record of the dealing. But in Hong Kong, there is a time frame of within 3 working days after the date of such dealings. The second difference is that for Malaysian SAR, there is no specific place as to where to keep the record of dealings. But for Hong Kong SAR, it must be kept in Hong Kong. Therefore, as a recommendation, Malaysian SAR should follow Hong Kong's SAR by providing a time frame for the solicitor to keep the record after he dealt with anything in relation to the client's money.
As an analysis, it can be said that Hong Kong's SAR is more effective. By providing the time frame of 3 working days, it will be more efficient in safeguarding the client's interests, and the solicitor will have to adhere to this requirement of time and not take it lightly, and this will avoid any complication or any conflict in the future.
For Malaysian SAR, this can be found in Rule 7A, where it states 3 categories of person, including an advocate and solicitor, second, a partner or partners of a firm, and third, a legal assistant expressly authorized by a proprietor or a partner or partners of the firm. So this is very straightforward. Let's say I am the sole proprietor of my own firm, Fatini & Co., then I am the authorized signatory. But if I have my partners in the firm, then any of them are the authorized signatories. And the last category would be the legal assistant, where so long as I or other partners has given authorization for him to be the signatory, then he is considered to fall within the category under Rule 7A. As for Hong Kong's SAR, this is also provided under Rule 7A, where it states 3 categories of person, but it is quite different from our Malaysian SAR. This includes the solicitor, a certified public accountant, and third, a person approved by the council, which approval shall only be given in exceptional circumstances. Therefore, we can say that the similarity between these 2 laws is that an advocate and solicitor is the signatory to the client account. In regards to the difference, in Malaysia, only persons with legal background are authorized signatories under Rule 7A. However, in Hong Kong, it includes a practicing and a certified public accountant, as well as any person approved by the council in exceptional circumstances.
So we can see that both laws share the same objective, which they only allow specified categories of person to be the signatories to the client account. However, Malaysian SAR is more rigid in the sense that it only allows people with legal background. So, which one is better? We believe that Malaysian SAR is better because although it is rigid in the sense that it aims to safeguard the client's interests by not letting more categories of people to be the signatories to the client account. This is because the more categories of people allowed by the law to be the signatories, the more the probability of misuse of clients' money to happen.
Both countries have similarity in terms of addressing the requirements for mechanical or computerized system of bookkeeping, which this can be seen under Rule 12 Sub-Rule 1 of the Malaysian Solicitors Account Rule and Rule 10 Sub-Rule 5 of the Hong Kong Solicitors Account Rule. Both provisions provide that all books, accounts, ledger, and records in loose-leaf books and such cards or other permanent documents are deemed to be in either mechanical or computerized system. Based on Rule 12 Sub-Rule 2 of the Malaysian Solicitors Account Rule and Rule 10 Sub-Rule 5A of the Hong Kong Solicitors Account Rule, we can see that there is a clear distinction between Malaysia and Hong Kong in terms of computerized bookkeeping. In Hong Kong, the provision particularly stipulates the procedure and requirements of ensuring this computer system to have first enough capacity and backup capability to record the information, and that second, the system itself must be backed up at least once a month. These two requirements are for the solicitors to fulfill whenever they decide to keep the records by way of computerized method. On the other hand, in Malaysia, the provision mainly discusses the procedure of records removal from the computerized system. Under paragraph B, we can see that if all accounts were to be removed from the computerized system, the solicitors have to copy the recorded information to a storage medium before the removal takes place. And under paragraph C, the audit trail or other record of the computer's input and output is retained for 18 months from its last entry. Based on the mentioned rules, it can be inferred that Rule 12 of the Malaysian Solicitors Account Rule is silent on the need to back up the recorded information in computerized bookkeeping, as the rule does not provide any specified measures that the solicitors need to comply with if the account and ledgers are kept in electronic form. Unlike in Hong Kong, there are no requirements stipulated for the solicitors to ensure that such system has enough capacity and shall be backed up within specified period. Conversely, the Rule 5A of Hong Kong Solicitors Account Rule is also flawed when it comes to situation where the record or information is being deleted or removed from the computerized system. And unlike Malaysia, there is no obligation for the retainment of the audit trail and the computer's input or output for the period of 18 months from its last entry. Therefore, the Hong Kong rule in this matter is not entirely sufficient. Regardless of that, we believe if Malaysian law firms are leaning towards the usage of electronic form of keeping records, the Hong Kong Solicitors Account Rule of backup system requirement should be made as reference, considering the backup system is the basis of ensuring the safekeeping and the integrity of the data. Though such computerized system may not cover for all firms in Malaysia, however, we cannot discard the fact that there are firms which have moved towards the computerized method since it uses little to no space at all. Thus, specific provision providing specific measures that the solicitors need to comply with if the account and ledgers are kept in electronic form, as in Rule 10 Sub-Rule 5A of the Hong Kong Solicitors Account Rule, should be included to guarantee a standardized computerized system.
After a thorough analysis on both rules, it is inferred that the Hong Kong SAR is proven to be more comprehensive than Malaysian SAR in regard to matters of managing the legal firm's client's account or in general safeguarding the client's interests. We opine that the lack of protection for the client's interests under the Malaysian position has indeed resulted in lawyers mismanaging their clients' monies and got away with little to no repercussions in reciprocation. Therefore, an immediate action from the relevant authority, such as amendments, should be done to prevent such situations from occurring in the future, or if it does, severe consequences should be imposed against the offender. The necessary changes can be done by cross-referring to the Hong Kong Solicitor Account Amendment Rule 2012.